So I'm very honored and happy to introduce and moderate this panel about AI vulnerability and dependence on social media. The panel is organized by RESOCIAL. RESOCIAL is a project funded by the Dutch Research Agenda about vulnerability and resilience on social media. It's a Dutch project, but has an international breadth because we have 14 partners, including institutions like Data Protection Authority, Consumer Protection Authority. We have BEUC and many other partners, and for universities from different fields. Constanta will tell more about the interdisciplinary nature of the project. So the topic of today is not just timely, but it's urgent, and so we will try to analyze it with many speakers, amazing speakers, and we will try to see how the policy also, policymakers should react to the topic of vulnerability and dependency. Just to say that vulnerability is now becoming an important keyword at CPDP. Several years ago, we vulnerability guys were a bit alone, and now there's a big bunch of actually in every panel at least once that word is mentioned. I will rapidly introduce our speakers, but you see them already here and the time is short, so I will just rapidly read their name and affiliation, and then we can start with the first intervention. So at my left, Kim van Sparrentak, from a member of the European Parliament for the Green Party, and then we have Constanta Rosca from Leiden University, postdoctoral researcher, Adele Zeynep Walton from Logging Off Club. Everybody will tell more about their affiliation and story soon. And then Damian Clifford from Australian National University, and Itxaso Domínguez de Olazábal. It's always very difficult. Yesterday I had to record a podcast about this panel, and I had to stop when I said your name, sorry. And from EDRI, European Digital Rights. So I would rapidly start with Constanta because she will tell us what's the state of the project and the survey that we are now analyzing, the data that we are analyzing, and I think she has slides.
Yes, I do indeed.
The microphone.
Oh, yeah. And I think we're still... Yes, the slides are on. Thank you so much for having me on the panel. My name is Constanta Rosca, and I'm a postdoctoral researcher at Leiden University, working on the RESOCIAL project, which is led by Gianclaudio.
It's closer, yeah.
Is this better?
Yeah.
Perfect. And I would like to introduce through this very short presentation the RESOCIAL project and how the work that we do at RESOCIAL is relevant for the discussion today about the regulation of social media platforms in the European Union. The main aim of RESOCIAL is to generate a greater understanding of user vulnerabilities and sources of user vulnerabilities on social media platforms, as well as how we can mitigate user vulnerabilities on social media platforms through platform design, but also through regulation. And the main motivation behind RESOCIAL is the urgent need to generate greater and more contextual understandings of the sources of user vulnerabilities on social media platforms. Social media platform design can lead to the exploitation of user vulnerabilities, for example, through dark patterns. At the same time, the regulatory landscape is changing rapidly. Recently adopted legislation in the European Union, the Digital Services Act and the AI Act, impose legal requirements on social media platforms, and more regulation is forthcoming in the form of the Digital Fairness Act. So this regulation, existing and forthcoming, requires prioritization, and it requires operationalization in terms of platform design that is vulnerability sensitive. So against this background, we see that there is a clear need for interdisciplinary insights that generate more contextual understandings of the sources of user vulnerabilities on social media platforms. And with this in mind, we have assembled a team of researchers from 4 Dutch universities that bridge the gaps between law, social sciences, and computer science, And together with this team, we have designed a survey, the main goal of which is to generate greater insights about the ways that users experience vulnerability in relation to the design of social media platforms, and more specifically, engagement-driven design. What we mean with engagement-driven design is dark patterns that try to capture the attention of users. These practices have been mapped by researchers from the field of human-computer interaction, but there is a need for a greater understanding still on how these practices, such as autoplay or infinite scrolling or capture notifications, affect users and how users experience exposure to these practices. We're also investigating what kind of mitigation measures vulnerable users deem desirable in terms of platform design, so that we could also inform policy efforts, whether they be existing or future. And the reason we decided to focus on engagement-driven design is because we think that engagement reflects the very core of the business model of social media platforms. But at the same time, engagement-driven design can be a source of harms in and of itself. So think about decreased well-being or behavioral dependencies, attentional harms. But at the same time, engagement-driven design is an amplifier of other user harms. Users that spend more time on a social media platform will, for example, surrender more personal data than they would like to, see more personalized ads, and they could eventually end up spending more money and experiencing financial harms. Our survey consists of 6 building blocks. We start by asking users about some basic questions about their demographic information. We ask users about which platforms they use and why they use these platforms. We also ask them about their usage patterns, so how much time they spend and how much time they think they spend and how much time they actually spend, so that we can look if there's deviations in this regard. We have a block of questions dealing with a wide range of harms, behavioral dependency, decreased well-being, financial harms, and privacy harms. In block 4, we ask users questions about resilience strategies. And in this regard, we ask them, for example, if they use legal mitigation measures that are introduced by the Digital Services Act. So if they check the terms and conditions to gain a little bit more insight into the main parameters underlying the recommendations that they see on social media platforms. But we also found the literature on digital detox and well-being very inspiring in this regard, so we also included a lot of extra legal mitigation measures that users could find desirable in terms of platform design. In block 5, we ask users to explain what they think makes them vulnerable and other people vulnerable in their own words on social media platforms. And lastly, we have a block of questions in which we have screenshots of particular design practices from social media platforms. And we ask users about whether they've been exposed to these practices, but also what their experiences with these practices are, and if they find them harmful, because ultimately we would like to see if there is a link between harms that users experience on social media platforms and exposure to this kind of design practices. We've completed data collection recently. In our data collection efforts, we targeted users that are users of very large social media platforms that reside in the European Union and that are adults. And we will be also rolling out a teenager-friendly version of the survey in the coming months. We have a diverse sample which spans 20 member states, although some member states are more represented than others. Different online platforms that are very large online platforms under the Digital Services Act, and different education levels and a wide age range. And while data analysis is still ongoing and is being conducted by our brilliant postdoc at TU Delft, Gianclaudio Hockenbroek, I would like to already present you with some very preliminary insights. So one of the questions that we asked users in our survey is what they would ask social media platforms to change in their design in order to make them less vulnerable or to make other people less vulnerable. And we've analyzed around 1/4 of this data, and we're starting to see a clear trend emerging, and that's that the design changes that users are asking for are already legally mandated. Lots of users, around 25% so far, are asking for less personalization in terms of recommendations that we see on social media platforms. They're asking for more control, and they're asking for more transparency. And the Digital Services Act already requires transparency in terms of recommendations, and it also requires providers of very large online platforms to provide alternatives to recommender systems that are not based on profiling. And these preliminary insights, in our opinion, suggest that either the level of protection afforded by current legislation is insufficient, or the way legal requirements are translated then into platform design means that rights that the digital rulebook grants to users are rendered meaningless when they are implemented into the design of social media platforms. This, of course, is very preliminary data, but also a survey is not the best way to gain insights into user needs. So our postdoc at Twente University in the Netherlands, Lorena Sanchez-Camoro, is currently also conducting co-design sessions with users in order to elicit more information about the needs of vulnerable users in terms of platform design. And that is what I wanted to throw into the mix of this discussion, and I look forward to the follow-up.
Thank you so much, Constanta. I think this was already a lot of food for thought for the incoming discussion, and hopefully next year, next CPDP, we'll have more data analyzed, also thanks to the workshops with representatives of data subjects and consumers and end users. I will now like to go to Kim. You were the author of one of the first, maybe the first legal and policy source mentioning addictive design in the title and even in the content. I mean, it was the first time we saw addiction connected to social media in the legal discourse when you last legislature in the European Parliament released the report on it and, well, the resolution, I guess. Where do we stand now with the DSA? Is it enough? Is not enough? Maybe not. And where do we stand?
Well, I wrote that report, of course, after the DSA was adopted. So I think you can already get out of that we were worried that the DSA wouldn't be enough. Also because the DSA, of course, regulates online platforms. And when we're talking about addictive design, that's not only in online platforms, but there's a lot of different tricks that are being used on our devices as well. And that's why we are looking for more horizontal legislation in the field of consumer protection, by which we can make sure that addictive design practices are being banned, full stop, on social media, but also in our other apps, because in general the idea behind it is that it's of course absolutely ludicrous that we have a situation where you can when you download an app or buy a digital device, you get the most addictive version, and there's not a single way in which you can change that. That's why we suggested the right not to be disturbed, which is basically the right to, when you buy a product or download an app or a service, you get the non-addictive version. If you really want to, you could perhaps opt in to certain things, but certain things are so harmful they should be banned. Where we are standing now is that, what is very interesting actually is that, the report came out and 2023 was adopted with a very broad majority in the European Parliament. And after that, it was very clear that the European Commission, the Digital Services Act enforcement team really immediately also looked into what they can do when it comes to addictive design. That also led to, for example, the banning of TikTok Lite, which is the only act that there has been so far when it comes to the DSA. And from that, we've already gotten a bit of a better picture what the DSA can already do when it comes to addictive design. But it also already shows that that's not enough and that we need more. And that's why there's now broad discussions in the European Parliament and the European Commission on the upcoming Digital Fairness Act. The Digital Fairness Act is actually the follow-up of the Digital Fairness Fitness Check. It sounds like another legislation, but actually it's basically an update of already existing consumer protection legislation that needs to be updated for current times and has a fancy title. So before anyone is like, no, we can't have more legislation, don't worry, it's an update. Where in this we will look at many different things. We will also look at gaming platforms, because of course we know that there's a lot of people that also show vulnerabilities there. We have loot boxes, of course, that they call loot boxes, but in the end it's just gambling within games. We're going to look at services in general, and also then to see if certain things that are being done by social media can be more clearly changed. And the most important thing there is to make sure that it's not up to users anymore to prove that they are being manipulated, that they are made addicted, but that we reverse the burden of proof. And that before these platforms put updates on the European market, they first have to show that they use the different dark patterns that we are aware of in a way that is not dangerous or addictive, or they don't use them at all. So that is actually the most important, and probably is going to be the most difficult thing. We want to reverse the burden of proof and to change the way in which we are now completely helpless vis-a-vis very big companies that are only trying to make sure their CEOs have more big super yachts.
Thank you so much. And of course, we understand the challenge in a changed political situation, to say the least. But now I would like to ask to go on with Adele, because she has a story. she wrote a book called Logging Off, and this is also an association, an organization, right? And it's about this, about addiction, about social media, let's say, adverse effects.
Mm-hmm.
But I will not tell more because you can tell us the story.
Thank you. Hi, everyone. So I'm Adele. I'm the author of Logging Off, The Human Cost of Our Digital World. My background is I'm a journalist, and I started reporting on tech policy and online harms after I lost my sister to online harms. So my sister was 21. She passed in 2022 when she was essentially drawn down a rabbit hole online into finding a forum that promotes and instructs people and encourages people to take their own lives. On that forum, she was able to acquire a substance and learn how to do that. And the two founders of the forum are also the founders of the world's largest incel forum. So they have 4 forums, and the only one that women are allowed on is the suicide forum. The Centre for Countering Digital Hate have done quite a lot of research on this forum, and also on their incel forum. And since 2023, the incel forum has doubled in membership. I'm now a member of Bereaved Families for Online Safety in the UK, which is a grassroots organisation founded by Ian Russell, the father of Molly Russell. So it's not only my sister, but there's a group of around 10 to 15 of us now, parents and siblings who have all lost loved ones, a lot of them children. Some have been lost because of online challenges, which are obviously designed to maximise engagement and are not safeguarded. Some have passed because of being bombarded with content that promotes depression, anxiety, self-harm, eating disorders, and things like that. And some because of violent crime that has come out as a result of being exposed and radicalised online to that type of content. We are working with the government, trying to press them to enforce the Online Safety Act to the best of their ability, speaking with Ofcom a lot of the time, but obviously there are big challenges with that. And I think my main concern in relation to my sister is, when it comes to vulnerability, is she was neurodivergent. And I think from my research with my book, there are vast links between neurodivergence and vulnerability online to addictive design. Of course, we're all vulnerable, but in particular, neurodivergent individuals can get drawn into these rabbit holes and into isolation at an even faster rate. So I guess I'll leave it there for now, but yeah.
Thank you so much for sharing and for your witnessing activity. And we will go back to the policy implications later, because you mentioned indeed the Online Safety Act. And speaking about policy, I'm happy to go with Itxaso now about, so you are at EDRI, you are on so many dossiers and files, the Digital Fairness Act, but also you followed the Data Protection, AI, etc. No. AI Act, DSA. Well, you have been in many, many tables. But my question is, what's the fight now? Where are you fighting now as civil society, looking at these problems and this topic? Thank you.
Thanks so much, and it's an honor to be here.
Closer to, yeah.
Sorry, it's me. I work for the EDRI office, but we're a network of more than 50 digital rights organization experts, and many of them are worried about all of these issues. And I like how when it comes to vulnerability and dependency on social media and the topic of this table, which is broader than just vulnerability and dependency, it's everything that we've been working on for years overlaps, and we see, a clear sense of purpose, right? Because when we started working on the DFA, somebody will have said, no, EDRI has never done consumer law, and this is, as Kim was saying, this is just an update on consumer law, so all of you shouldn't be interested. I'm like, no, exactly the opposite. Consumer law isn't fit for purpose when it comes to all of these dynamics that EDRI and its members have been studying for especially, and not just the dynamics, but the online harms that they cause. Something that I think everybody in this room can agree to is vulnerability is not a side effect. It is built into the system, right? I've always hesitated when using the words business model, because I know how contentious that is, but it's the business model of these platforms, the business model of all of these companies. Platforms are not just places in content circulates. At the end of the day, there are machines, and we have to consider them as machines, in which that shape how we feel, how we behave, what we see, and how long we stay, because of the money it has made. And I have already told the anecdote 3 times today, but I think it's interesting because something that we keep hearing, and I've heard that from institutions, even in this, people like personalization. I'm like, okay, people like personalization. Of course, I like to see the shoes that I've always dreamed of, but people do not know the dark side of personalization. And yesterday, there was a showing of the film, The Click Trap. I don't know if you watch it, but what are all the harms of all of this data that is taken from you? And we can speak afterwards about how all of this depends on the data that is taken from you, that is used in order to harm you and the society as a whole. So something that I think civil society has clearly stated for long is that manipulation is not an accident, it's a business model. The TikTok feed is the perfect example. We believe it's tailored to what we want to see, but it's not. It's showing you more of the things that you want to see. Something that I think it's interesting for us to understand is that industry is already presenting profiling as something that is good for us and good for society, and we have to counter that, because again, all of this depends on profiling. All of us are vulnerable. Thanks so much, Adele, for saying that, but some people are more vulnerable than others. I'm thinking of people with disabilities, neurodivergent, all of the people that are prey to discrimination, structural discrimination, racialized people, LGBTQ people, and also children. But as we know, children are being most of the time used as an excuse in order to implement large hammer measures. Children don't deserve to be on the internet, instead of trying to understand the harms that children are suffering as a symbol of how structural all of this is, and how we need to address all of it for adults, for children, in order to have a safer society. 2 last things, because I see Gianclaudio, so it's, people are also blamed for being manipulated, because something that we're also seeing increasingly is this idea that if you have digital literacy, it's going to be okay. As long as you educate people, children especially, everything is going to be okay. And I think I'm not sure it's bad faith or lack of knowledge, people do not know how. No matter how literate you are, there's so much that is designed in order for you not to understand and not to even know how it works. For example, when it comes to tracking, there's this idea of fingerprinting. Even the most sophisticated injury is never going to be able to know how much data they're taking from them. And the same for dark patterns. They don't call them dark patterns, and it's impossible for them. And even academics that work on dark patterns for months, for years, they are not able to. So stop with the bullshit. Digital literacy is great, but we need to take action. And as Kim was saying, and we're going to speak about the policy side of it, I think we need to ban some practices, and maybe we need to do more things, and I'm looking forward to the conversation.
Thank you so much. And your input on vulnerability definition was key, because in the project we started with the vulnerability definition. Maria Rebran and I have worked on that. But now the end of the project will also go back to how policymakers and institutions, in particular in the Netherlands, but we will try to be broader, understand vulnerability, if it's a static or a dynamic concept. So, and of course, this is very important. There are sources of vulnerability that interact with the context and with the relationality. So we hope, at least, for example, in the AI Act, the discussion will be broader than the current one. But now I would like to go to Damian. So Damian, you're here for many reasons. First of all, you are one of the first legal scholars who have compared very, very deeply data protection and consumer protection. And these two things are really here on the table, even before that DSA and the AI Act were a thing. Secondly, you are in Australia, and it's the country now on the news because it was the first, well, not the first, but one of the first one of the first global north countries to, I don't know, one of the first countries to regulate social media, to ban social media for teenagers. So here I'm asking you to combine these two perspectives, that like being a scholar on these topics, but also in that country. What do you think?
Yeah, I mean, I guess the question is, what can we learn from Australia? And I suppose the short answer to that is probably how not to do things when it comes to the ban. And I guess that when it comes to bans, I'm, I suppose, both optimistic in terms of their capacity to engender some change, but also a little bit pessimistic in terms of their capacity, because of the impact that policymakers, I suppose lobbyists, can have on the design of bans. The ban for under 16s, for social media ban in Australia, suffers from a number of flaws that are very clear. Yeah, I mean, the whole idea of it was ill-conceived. It wasn't research informed. It got broad-scale public support. It coincided, I suppose, its adoption with an upcoming federal election. So the very cynical part of me thinks that it was low-hanging fruit that had broad-scale support, but is actually going to make no difference at all, or whatever difference it does make will probably be harmful. And that kind of reflects some of my hesitancy around bans in many ways. My feeling is that we have a lot of law. I suppose I'm putting on my EU hat here. We have a lot of consumer law. We have a lot of data protection law. We have now a lot more law since I left for Australia 6 or 7 years ago. I think that what we need is enforcement. So I think that there are actually quite a lot of laws out there that would ban, like prohibit, much of what happens online if they were correctly enforced. So I think, you know, I haven't been to CPDP now for 6 or 7 years. Coming back, I think we kind of fundamentally have the same issue. It's just a lack of enforcement. So my hesitancy or my, I don't know, anxiety about the adoption of another piece of legislation is that we're just going to have another piece of substantive law that says that these practices aren't good, and then nothing will happen from it. Now, maybe I'm just going increasingly cynical. Maybe there is benefit to having that clarity, the legal certainty, but I'm also wary of the fact that bans, when they're implemented and institutionalized, and I suppose they're debated at the policy-making level, can be watered down in the production. I think we've seen that, for instance, in the AI Act, which has implemented certain bans. Those bans have carve-outs, and then on the basis of those carve-outs, or the restricted bans, shall we say, I mean, a good example would be the emotion recognition stuff, but what does that mean for other contexts? Is it legitimizing it? So I am somewhat in between. I like principles-based regulation for that reason. And in some ways, I suppose if I was to position myself as a civil society person, which I'm not, I am very much an academic, I would see the benefit of principles. Principles allow you to argue flexibly with developments in technology. Bans can be restrictive also as to what they don't include. So I think it's just maybe a cautionary message, and one that I'm just trying to maybe add a little bit of nuance on the basis of experiences, I suppose, both here but also in Australia.
Thank you so much. I think your message is very clear. So, because principles and enforcement need to be together. Principles means a regulation based on the proactivity of the enforcers. So we need also a political, legal systems that supports proactive enforcement. And we see that if the Commission is enforcing, for example, the DSA, then there are influences coming with the time and waves. But we will go to this now in the second round, in which I would like to ask to our panelists, what do we expect from the future? I think most of you already mentioned future challenges. So before opening to the Q&A, I wanted to ask Kim and also then the other speakers, do you see the DFA as something, well, realistic, but also what you, as a member of the European Parliament who has been vocal on these topics, what you will expect as being essential elements of an acceptable or good DFA? Because this will be probably the only new digital act in this legislature. Well, we will see, because, but the one in which they are investing. So.
Yeah, depends. I mean, if you consider reopening all digital legislation and then slashing it and getting rid of half of it is also considered a new act. I mean, it's a bit tricky to now say what is acceptable, because within the current political situation, we can be happy with every little crumb we're getting, because the far right is extremely vocal, especially on digital legislation. They will immediately bring forward that, I mean, just this week I was still accused of being the biggest danger towards free speech because I want to protect people from addictive design. And that was by an EPP member, not even the far right. So I think we are up for a very, very difficult situation when it comes to what we can hopefully get. Nevertheless, there are in every political group that is pro-democratic. We mostly we can expect we have enough allies, people who understand the dangers, who see the harms, and who want to go forward. But I find it a bit tricky to say what can be acceptable, because, as I said, we don't really know what we can get. However, what I would like to see is really making sure that we take digital dark patterns and other things that are put into products and services way more serious. We have in European consumer law things that are not allowed. You're not allowed to manipulate people, by pretending that something is 50% off in a shop, just by putting 50% off of something that it was always 10 euros, And I think when it comes to the manipulation that is being done online, we can be way more strict and way more clear. So if you look at one of the issues, of course, of the enforcement of the Digital Services Act is that a lot of things are very much up for interpretation. And of course, it's all legal. Lawyers love to discuss forever what every word and comma means. And that's why I really hope that in the DFA, we can be very clear, so that we are just very clear that the combination of an endless scroll with autoplay is unhealthy for our brains can't handle it, and that, we should have considerations of banning that. But also really making sure that, all the other things that we know are addictive, such as the like button, the way that the algorithms work, to really make sure that they are also on a list, and that it's up to the companies to prove that it's not harmful. And that would really be, I think, the most important thing. And in general, what I hope is, and that is going to be very difficult, I think, is that it's we apply the same rules to every group. And that is still, I think, going to be a discussion, because it's way easier if you to say I'm saving the children. I mean, that's the dream of every politician to be able to say that. I always get the feeling. But actually, we have to make sure that we really learn indeed from, for example, what's happening in Australia, where they say, no, we're just banning social media for kids and they will be happy again and nothing, and that's the end. Whereas we all already seeing the problem of YouTube, for example, not being included there. So I think it is important that we are very clear in the legislation, and that's also what I'm aiming for.
Thank you so much. Yeah, I think the Australian example indeed was very relevant. I have a lot of thoughts, but as a moderator, I should restrain. Maybe just saying that in our project we have also Professor Simone van der Hoof, who has been vocal on the topic of against this ban also in the media. So there will be more to say. But I wanted to go again to Constanta, because also in her thesis and book about dark patterns, she has also interviewed policymakers, and maybe I guess you have a view of what the DFA should contain, or what to expect, or what we can expect.
Thank you so much, Gianclaudio. Just a small correction. I haven't interviewed policymakers, but I have worked with them before. Okay. So I feel that, in my opinion, what transpires from the contributions of the brilliant speakers on this panel today is that technological design can be a source of user harms, and therefore there is merit in regulation engaging with the design of technology. And in this regard, I dare say that I disagree with Damian. I do believe that we need more regulation in the form of the Digital Fairness Act, and that is because the Unfair Commercial Practices Directive has recently celebrated its 20th anniversary. It has remained extremely relevant in digital markets due to its horizontal and therefore very broad scope of application. It doesn't just apply to very large online platforms. It applies to small to micro enterprises in the European Union. It doesn't just apply to particular business models. It applies to everything that is not, for example, an online platform and deploys a dark pattern. So think about individual e-commerce websites that are not online marketplaces. Think about dating apps. Think about video games, which are all sectors which do also deploy dark patterns. Another reason why the Unfair Commercial Practices Directive has stayed so highly relevant is its technology neutrality and this principle-based rules that it deploys in order to prohibit unfair commercial practices in the EU. At the same time as also the Digital Fairness Fitness Check of the European Commission has shown, and as I write in my book, thank you so much for promoting the book, Gianclaudio. At the same time, the technology neutral construction of the Unfair Commercial Practices Directive has failed to provide sufficient legal certainty for traders to be able to design compliant user interfaces. This legal uncertainty also affects the work of enforcement authorities because enforcement authorities, national consumer authorities in the European Union, in member states, have to detect and penalize infringements at scale. And the scale of the market that they need to supervise is much bigger. Yeah. And in this regard, they may be hesitant to act, for example, in a context of legal uncertainty, but also providing more clear-cut rules about dark patterns could potentially also lead to the development, for example, of automated market monitoring tools for particular markets such as e-commerce websites, which could also make the work of national enforcement authorities perhaps easier. And there's also, I believe, urgent need to clarify the interaction between old instruments, such as the Unfair Commercial Practices Directive,
and new instruments, because new instruments, the Digital Services Act and the AI Act also regulate the use of dark patterns. And an online trader can also be an online platform. They can also be an AI deployer. So I think in order to improve compliance, but also to make the work of enforcement authorities, which have to navigate an increasingly complex regulatory environment, easier, I think that I would like to echo Kim's hope in this regard for the Digital Fairness Act, but the Digital Fairness Act will lead to greater legal certainty when it comes to the regulation of dark patterns.
Yeah, this is a key legal design question, whether we should go for principles that have some margins or for very technical specific solutions that of course there might be drawbacks, but I would like Damian then to respond. So we skip for 1 second Adele and we go back to her. Yeah.
Yeah, no thanks. I mean, I suppose I'm not completely opposed, I'm just cautious, yeah? So I guess that's probably the distinction or nuance I'd add, you know, I mean, and I guess with that, you know, the more certainty we strive for in these laws, the more complex they will get. It's kind of, you know, if you look at you compare the old data protection directive with the GDPR, yeah, it just gets longer and longer and longer, and that's kind of a trend within EU law. So I guess that's where I'm coming from. It's not I mean, it'd be kind of an odd thing for me to say that I'm opposed to the idea of getting rid of dark patterns. I mean, I'm just kind of cautious about the way we go about it, given, I suppose, some of the unforeseen impacts that laws can have because of, I suppose, regulatory design failures. And that's something I suppose I'm starting to look at a little bit more in my research. So I'm kind of at a preliminary stage, so I'm grasping a little bit at straws. I mean, I suppose to connect some points, but it's probably a sense of anxiety around what might actually stem out of it. Yeah.
Yeah, and when talking about this, of course, the point is also that how the policy making works. Now there's so much emphasis on evidence-based, and when we talked with the European Commission, DG Justice people who are working on the FA, they said, if you prove me that infinite scrolling is a health issue, then we can act. But fundamental rights are a bit more than just health, so there's this also this, and consumer protection is now, I think, large enough to also have fundamental rights in a broader spectrum, and that's why I would like now to go to Itxaso about what do you think about this, like principles, prohibitions, what is your favorite DFA?
If this is a wish list, I think a sensible combination of many instruments and many techniques that have proven useful in the past could be good for the DFA. Again, something that we have to do is be as ambitious as we can, because we know that the message from everybody, from industry, of course, from the media, from the institutions, is that you don't have to be ambitious. Even there's people saying we don't need a DFA. So, but then that's why we need to be even more ambitious. And something, so for, of course, you know, blacklisting, you know, this is why the Unfair Commercial Practices Directive is so useful. You know, Article 5 is not being used the way it should, but the blacklisted practices are, and the good things that you can update that, right? But I think we can speak about enforcement afterwards, because there's a huge problem with enforcement, right? And something that I would really like to see in the DFA and maybe in other laws is not just a better coordination between consumer authorities and inside the group of consumer authorities, but also cooperation between with other regulators, right? And I think this applies for all the laws, but when it comes to this, because I'm thinking, and this is very interesting. I don't know if many of you know Article 15 of DMA. Companies have to prepare a report about their profiling activities, right? And they have to publish to share that with the EDPB. There's a public version. It's all redacted. It's not fun. If anybody has a full version, I'm willing to pay for that. But okay, they have to share that with the EDPB. The EDPB is not going to do anything. The DPAs are going to be afraid. Wouldn't be wouldn't it be amazing that they share that with the market surveillance, with the consumers regulators, because then you get action to act, because, and this is something that we cannot emphasize enough. None of these practices for us can be understood without profiling, without pervasive tracking, right? So this is why at Edru we are preparing a position paper, and I'm being very annoying with that. Besides blacklisting practices, I think we need to do something with consent. We need to do that with the interfaces that collect consent. They have to, in order to be fair, this idea of fair consent, not just consent that applies with the criteria of GDPR. And I think this is central, right? Because the consent that we've seen, and again, I don't have to give you the example of the cookies, is not enough. It's completely meaningless, and it's not fair. Seeing that we are using the term fair. So I think that's also something very important for us, besides just blacklisting practices and improving enforcement. Being very ambitious, and this is something that many academics say, maybe we'll also have to make a regulation similar to the DSA, so that the large platforms and the platforms that are the most harmful are monitored and sanctioned by a centralized enforcer. I know how contentious that is, but again, we're speaking about something that is very harmful to society, and also when it comes to these practices, precisely because they are so harmful, and this is why I was referring to the usefulness of these profiling reports. We need transparency. We need meaningful transparency, and we don't have transparency. And the companies are not willing to do that, and we need the impact assessment. Otherwise, again, I don't want to enter into this horrible debate and never-ending debate about rights-based or risk-based regulation. If this regulation is risk-based, I'm going to throw myself out the window, because it doesn't make sense. As you say, it has to be principle and rights-based, but then we need very powerful impact assessment. And as Kim said, I cannot emphasize that enough, reversing the power, presumption of unfairness, and reversing the burden of proof. Again, we know there are, all of these are unfair, and many more of what we think are unfair. So yeah, they have to prove it, otherwise they shouldn't be in the market.
Yeah, great. So I think there is a kind of a consensus on this, I would say grey list, if not blacklist, so a presumption of harmfulness that should be flipped if possible. But I would like to ask now Adele, so you mentioned the UK situation, the UK Online Safety Act. Also your personal story and your book refer to a situated case where there are intersection of different vulnerabilities. And so this also goes back to the question of whether we should consider groups and a specific situation, or we should go more transversally. How do you see that in a policy, future-oriented
No, thank you. I mean, something I think is really important is we need more people with lived experience in the policy-making process, in the rooms, having these conversations around policy, because I think it just gets so far removed from our everyday lives and our own experiences that by the end of it, decision makers are tired of debating about, words and sentences and clauses and things, that they just think, right, let's just go with this, but they don't actually know what the impact of that is going to be on people's lives. I think also, like you said, we really need more collaboration between not only enforcement actors around tech, but also other institutions like police, law enforcement institutions. I mean, something in our case around my sister's experience is that there's an ongoing criminal investigation. And at the point when that started, I don't think the police had the digital literacy to know to request data from these companies or to know who to go to. And there's a real gap in knowledge in anyone who is outside the tech bubble. And that means that we're failing people because health professionals don't know what to do, police don't know what to do, and they don't know what their role should be in making sure that the Online Safety Act is effective, for example. Because if we only have people in a small bubble around tech policy or, say, just Ofcom thinking about this, then it's not going to work and it's not going to protect people and keep people safe online. And in terms of the Online Safety Act, it's a mixed bag. Bereaved families for online safety, from all of our perspectives, I think we're not hopeful that it's going to keep people safe, children or adults. And with the children's codes recently, we were very disappointed. We felt that it was very lax. And Ofcom, I don't see how Ofcom can be responsible for enforcing against tech giants. I mean, it's just the scale of them, and for Ofcom to be responsible for that. And I think now we have a position where we're going to MPs and saying, look, these problems still exist, these problems of harm still exist, and we're told, well, we've got the Online Safety Act now, so just wait and see how it's going to pan out and you'll be fine. And I would really love to see more public consensus around the need for a ban on addictive design, because I think if parents understood that, if young people understood that, and that's where in my work as a journalist, I really am trying to educate people who are outside this bubble of what's happening, but also like it can be fixed, there is an alternative. So I would love for us to be having more conversations outside of our bubbles and translating it, because half the time in this panel I'm like, what are they talking about? I don't know what you guys are saying, because it's so jargon filled, but I've written a whole book on big tech, so you know what I mean? And we need to bridge that gap, because otherwise we're going to have no action. People are going to continue to feel turned off when it comes to tech conversations, because we don't know what the impacts are until we experience an online harm, and no one should have to experience that.
And this is a great message. Like I see these days panels that actually are getting this, that we should move from transparency to legibility, and maybe also beyond. Legibility should not just be technical competence, but should be emotional competence in how to deal with the consequences of AI, and not just for the staff of deployers and providers, but also for society at large. So it's ambitious, but I think in the midterm, this should be, hopefully also in the short term, but I don't see it coming soon. Since I had the best speakers ever, we're super in time. We have time for Q&A, unless you have some comment that you want to do before the Q&A. Yeah?
I just want to say that at some point, you know, because it goes hand in hand with this idea of being less ambitious. We know we're being told this mandate is all about competitiveness, this fabricated crisis of competitiveness, and anything we propose for the digital fairness, they're going to come back at us and say, no, this doesn't help competitiveness, without any study. I don't know if you've seen that Meta is already pushing a study on LinkedIn and on social media about the benefits for society of their ad tech business model. So yeah, please don't believe this idea about competitiveness, because harming the people as a whole and harming some vulnerable communities is not going to help competitiveness.
Kim was seeking, but maybe she will. No?
You know, we're in this pretty bizarre situation right now, where in order for us to say, okay, you know, addictive design is harmful, we would have to have studies that, you know, have spanned over 50 years or something, which of course we can't provide. But meanwhile, everything that is now being done around competitiveness, I mean, we're criticizing the Trump administration for what they're doing with Doge, but there's not a single impact assessment done on any proposal that is being done in the omnibuses by the European Commission. So I also think that we should try to fight that double standard a little bit. That's so in case you're ever confronted with a Commission official that says like, oh yeah, but there's not enough proof, you can also ask them, oh, but since when do we still care about that?
Where's your proof?
Thank you so much. This is so.
Sorry, I don't want to be too cynical, but
no. I think that's what we need now.
We're gonna leave hopeful. We're gonna leave hopeful from this room.
Okay, so I see a first question by Professor Bert Jacobs.
Thank you very much. Interesting discussion. But what I noticed is you're so much focused on the existing online platforms. What about alternatives? We live in days of digital autonomy, sovereignty in Europe. Maybe we should invest more there and build things up in a proper way from the beginning. Is that on your agenda too?
Just to understand how many questions we have, so we can perhaps collect. Okay, we collect 3 and then we go for a round of answers. Yeah, first row.
Hi, thank you for this really interesting panel. I really started thinking about this question of enforcement crisis. And like of kind of my own experience also when I'm online and I see like a cookie banner where I'm like, I know for a fact that this is not compliant, but I don't know, like, what am I going to do about it? So I'm just wondering if there is on any level, like, are any of you engaged in or familiar with any sort of incentives or like initiatives that try to really like create a pipeline from the users and their experience? Because often, like, people will know when stuff is going on online that doesn't feel right, but like, what are they going to do about it? To kind of translating that into the pipeline of complaints that actually end up with the surveillance authorities. And there could really be a mechanism where if users file a complaint, platforms are being notified about these complaints. So then that increases the pressure when many people complain. They know this is a complaint to the enforcement authorities. So like the likeliness of actually being investigated will increase, and that will increase their incentive of actually counteracting that before being investigated. So do you know if there's anything like that in the works? Thank you.
And we had the third, yeah.
Hi, everyone. Thank you for the great panel. I'm Carissa Anderson from Privacy Salon. Going back to what Adele said, I think it was really great to talk about bridging the gap between policymakers and people in civil society. But one question came to mind. We've seen in the past with Snapchat and maybe some other social media platforms, I'm not sure what the current status update is on this, but where they'll refuse to give over data, saying it's been deleted because of their 24-hour data retention, whatever, and then using Section 230 as this liability shield from it. In that case, I guess, what is the next step to go to rectify these harms and ensure that they don't engage in this engagement and are able to contribute with law enforcement, et cetera. And it's also the question of what's more profitable, to deal with the fines and the cost of doing business or to enforce this. So I guess just what's your opinion on that?
I see we have more questions, but we go with this round of answers. So whoever wants to, maybe we follow the flow.
Well, I mean, there's an increasing group of people busy with the alternatives. I mean, digital sovereignty, digital autonomy, depends a bit what you like in terms of terminology, but we're meaning the same thing, is being discussed more and more. It is most often discussed in our cloud and AI sectors. Especially in AI, of course, there's also been a lot of investments announced, so that's where a lot of focus is going. But there's also an increasing group of at least members of the European Parliament who are trying to make sure that we look at the full stack. I guess you've already heard about the public stack, and really are trying to make sure that also some of the investments go to the broader infrastructure. And besides that, we are also, for example, when it comes to government finance and government used products, we are also really looking into the Public Procurement Directive to try to change it. But yeah, it is very difficult, right? Because we are completely dependent on a lot of these big tech platforms. Of course, as governments, we don't need to use TikTok per se. But on other big companies, we're definitely dependent. So it is starting to dawn on us, and it's not an easy solution, but at least there is discussion about it. And also, I highly recommend trying different tools. Absolutely, because
I don't see specific programs for focusing on alternative social media.
No, there are not there yet, because that's something that we're not there yet. But I mean, there are discussions about it. But it's also interesting because a lot of people, when you talk with them, the first reaction is, but it's impossible, so let's not even try. And that is a very, very, for me, that's too cynical, but we're going in the right direction. On the second question about enforcement and how to bridge the gap, I think it's a very relevant question. It's quite interesting that all the focus right now is, of course, on competitiveness. And one of the things that we're trying to do is to make sure that it becomes easier for companies to comply by creating one-stop shops for them. But I think it should also we should also consider it way easier for citizens to make sure that they have one-stop shops in case they have questions. I think we still have to hash out way better how people can reach the digital services coordinators in their national member states, for example. And I think it's really, really necessary as well. Because right now, there's people that are like, I thought I had more rights, but where are they? And how are they? So definitely something that is very necessary.
Yeah, maybe I will abuse again of my moderator role just to say it's great what you mentioned about dependency. We kept dependency in the title with the ambiguity of the term. There's emotional dependency and there's structural dependency. And with social media, we see both at the same time. So who wants to respond next to the first 3 questions? I saw Itxaso was really...
No, but I think my concern when it comes to the idea of alternatives, and I'm all for alternatives, is that we see European companies using the idea of competitiveness and by saying we need less regulation and also we need more money, but especially apparently now it's about regulation. But I also see them because I speak with some of them saying that as soon as they have it, they're going to become the next Google, and I'm like. No, I don't want to have a European Google. I want to have a company that actually protects people's rights and don't abuse. So I think this is something that we need to understand. When it comes to companies, if they're based in the European Union, may be better, but they have to comply with the laws. Because we also have amazing companies outside of the European Union who are actually amazing when it comes to complying with the law and with respecting privacy and data protection. And also I wanted to say something about, all of this idea of, this will be amazing. This idea of bridging the gap and going to authorities and letting them know that is already happening when it comes at least with GDPR. But there's a problem with apparently resources, and there's also a problem with a certain DPA. I'll let you guess which one. That doesn't want to actually hold the companies accountable, and when they do, it's just because others are forcing them to. So, and it's interesting to see how, what we're seeing is. For example, we saw today one DPA, the Hamburg DPA, going ex officio against Meta AI training and forcing an article that is underused in the GDPR because they knew that the Irish were not going to do that. So I think in principle is ideal, but also if you go to DPAs and you let them know hundreds and hundreds of people are going to come to you to signal that there's a problem, they're going to freak out. They're going to I don't know what's going to happen. So again, in principle, that's amazing, but I'm not sure this is going to. And with DPAs, I think this is the case with DSTs and with all other regulators, because resources, it's a thing. I'm not sure how it can be solved, but in principle that would be amazing, and they should follow because they're forced to handle any investigation or any complaint that they receive. But.
Yeah, and they had the same frustration about DPAs. Italian DPA does many things, and the other don't follow. So was one example. Do we have other reactions to the first 3 questions? Otherwise, I see 2 questions in the first row, maybe a third. Yeah.
What's the first question?
I'm Ulrich. I'm from the University of Oxford and the Reduced Digital Distraction Project. I had a question for Damian, and that's just so you were speaking about how the Australian bans of social media clearly was not working. I was just wondering if you just say a little bit more about kind of some of the reasons for why that was obvious.
Thanks. Ben Wagner from TU Delft, and also very lucky to be working with some of the wonderful people on this panel. I just have a question that sort of we've been talking about studies and evidence and all of these sorts of things that we would need, and it strikes me that half of the room roughly are academics. So if you could wish for like one perfect study that somebody in this room should write, not just you, but that somebody should write, that would give you the evidence you would need to write the DFA that you would really want, what would that study look like? What would it sound like? And what would we want to be discussing a year from now in order to ensure that some of the things we've been discussing here would actually be happening? Because it seems like there's a lot in place, but people don't really seem to see the broader societal relevance. So is there something that could be written or could be researched or could be studied that would really change that narrative? which we could then say that the use cases are there. It's very clear to like an individual level. It's incredibly powerful. You can see the individual harms created. Is there something that could make that narrative to show how broad those harms are and how widely they exist?
Yeah. And I echo these questions on behalf of RESOCIAL because we have so many data now that we can analyze and we can interrogate different forms and the correlations that we can find. So that would be very interesting. We have just 5 minutes, so I think we should stop with the questions and go with the final round of answers for this additional question. So, Damian first, yeah.
Yeah. The ban isn't enforced yet. So I suppose some of the uncertainties would relate to what's included. We don't really know what's included, what's excluded. For instance, there was kind of a bit of a backroom deal for YouTube, but we don't know whether that's reality or not. The government has come out and made certain statements regarding certain types of social media platforms. For instance, there's a possibility that gaming platforms are excluded from the ban. There's also messaging apps maybe excluded. So there's a lot of uncertainty about like the scope of the ban, which is a little bit insane. Aside from that, then there's obviously an age verification aspect to this. From what I understand, there's a last-minute addition to this act that basically said that you can't require giving government ID as the only option, which seems to imply it can be one of the options, but it can't be the only option. And then it's hard to imagine exactly what else they have in mind. Yeah. Some technical means, I'm not sure exactly. So there's a huge amount of uncertainty as to how it's going to apply, its scope. So I think that that's probably within the legislation itself. And aside from that, as a parallel, there were some Privacy Act reforms. As part of those reforms, there's now a code for children's privacy being developed in Australia. And it's unbelievably unclear as to how those two are going to interrelate. So I think the short answer is it's a mess in every way conceivable, I would imagine.
And to the second question, maybe Kim and...
Okay. First of all, and I'm not sure if this is possible, but for a lot of policymakers, it is very important to understand that social media doesn't have to be extremely addictive. Because one of the biggest fears, of course, is that you change anything in the business model. So in case there could be some comparative studies on different types of social media and the different addictive features, that would be really useful. The second thing I think what is very important is to see indeed if the difference between minors and adults is indeed that big that you should only have parts of the legislation only apply to minors, which is where it's sort of heading right now. And of course, we know also more about vulnerability of minors, and I also don't want to negate that they are more vulnerable, but whether exposing minors above 18 suddenly to extremely harmful social media systems is a good idea is a second. So that those two things I think would be the most helpful right now. But if I can have a longer wish list, hit me up.
I think, building on what Kim just said, I think something that would also be incredibly useful, again, unlimited resources, unlimited info, I think it will be to show how all of these designs, the impact that of all of these designs on parents have on children. I think at the end of the day, I think we don't realize, I think it's that children are impacted, of course, by what they see online, but also by what they see at home. They see people hooked on the internet that actually repeat some of the things that they say that they hear on the internet. So I think that second degree could also be useful. And also, again, wish list. Something that I think could be really cool. I'm not sure it's going to have an impact, just because I think there's such an obsession with people like personalization, is also trying to understand the level of knowledge that people have about what are the consequences of personalization. If people understand that by giving up your data to Instagram to see cooler shoes or cats, or again, whatever you want to see, or the Kardashians, these data might go back, bite you in the ass, and you're going to be seeing content. If you're using the Kardashian about plastic surgery, about skincare, even if you're 15 or 10 years old, like we've seen, I think I was reading Careless People, and I don't know if you see, but the moment they were saying that Meta, the moment they see you remove selfies of yourself, they start imposing you more and more content about skincare and ways for you to be thinner and more beautiful. And again, we're speaking about you removing selfies. That doesn't mean anything. So I think, again, how the level of knowledge of people, I think this is very difficult to measure. I know that I'm an academic myself, but something like that, I think trying to counter these horrible methods that people love having their data taken in order to see puppets, as the lawyer from a very famous company said recently. Thanks.
Thank you so much. It was you want to add final 30 seconds?
Just one more thing. I don't know. I don't believe that this is the argument that we should have to be having, but if we're speaking the language of a lot of MPs, like the economic cost of online harms to society, because the argument around tech regulation being anti-innovation, anti-progress, anti-economic, prosperity, and also societal prosperity in general, I think that's a myth that we really need to dispel. And if it means that we have to show in numbers that people experiencing online harms, whatever they are, is bad for our society and for the economy and is disruptive on such a wide scale, then we have to have that argument. Like, let's do it.
Absolutely. And yeah, with that, thank you all. And thank you all. It was an amazing panel. Hopefully, this topic will be stronger on this topic in the next CPDP. And now it's lunch.